Hi, welcome to my channel and please don't forget to like, comment and subscribe. Today I bring a topic about the law of salvage. Case tackles unique area of maritime law. The case note Mount Isa Mines Ltd versus the Ship Thor Commander 2018 FCA 1326. There is a long-established principle in maritime law whereby a person who helps recover another person's ship or cargo in peril at sea is entitled to be rewarded for their good deed. No, it is not called finders keepers, but the law of salvage and the case of Mount Isa Mines Ltd v. the Ship Thor Commander 2018 FCA 1326 examines many issues in relation to this very interesting area of maritime law. And the background is the Thor Commander or ship broke down on 11 January 2015 near the Great Barrier Reef on its way to Townsville, Australia from Chile carrying copper products or cargo. Her owners, Marship GmbH and COKGMS or Sinus Istum, the owners, arranged for attack the Smith Leopard to tow the ship to a nearby port in Gladstone. However, dangerous weather conditions at the time meant the ship needed to be towed away from its course, which would likely bring it aground on the Great Barrier Reef before the Smith Leopard. Which means the Smith Leopard arrived. So on 12 January 2015, the Australian Maritime Safety Authority or EMSA issued a distress signal for any ship within a 10 hours proximity to tow the ship to a safe position. A capsized vessel, the Hinfa Hai or Salvor, responded to this distress signal prior to the owners and the Salvor agreeing on a commercial arrangement. And owing to the impending danger of grounding, EMSA issued a direction for the Salvor to tow the ship to a safe position away from the Great Barrier Reef, while owners awaited the arrival of the Smith Leopard. The Salvor successfully hooked up with and towed the ship to a safe distance away from the Great Barrier Reef, and before letting her go to safely drift in open waters. The Salvor spent about 25.5 hours engaged in salvage operation. The Salvor claimed common law salvage as against the owners and the cargo on board. The judgment discusses a number of issues related to the law of the salvage. Was it a salvage operation? Were the salvage operation even necessary? What's a reasonable reward? Should the owners of cargo contribute to the reward? These issues are discussed below. Was it salvage or something else? One of the elements to the established salvage is that the salvage operations must be rendered by a volunteer, e.a. there must not be a pre-existing contract or official duty to undertake the salvage operations. This concept is preserved under Article 6.1 of the International Convention of Salvage, done at London on 28 April 1989 or 1989 Convention, which applies to any salvage operation save to the extent that the contract otherwise provided. The Navigation Regulation 2013 or CTH gives forces of law to Article 6 of the 1989 Convention, given the Salvor was acting at the request of EMSA. Could the Salvor be considered a volunteer? The court noted that the test of voluntariness was only applicable as between the salvor and the salved, being the ship. It was immaterial that the salvor had been requested to conduct the operation by EMSA. They cited various authorities which have established that a person who obeys a statutory duty or obligation can still be a salvor because that duty or obligation is not enforceable against the salvor by the ship in danger, but by a governmental authority, which in this case is EMSA. Notwithstanding, it did not matter whether the salvage operations were voluntarily performed because the definition of the salvage operations under Section 14 of the Navigation Act 2012 or CTH does not create a precondition that the salvor be a volunteer, just that the salvor salvaged the third commander in danger. Further, the protection of the sea powers of the Intervention Act 1981 CTH Intervention Act gives EMSA the power to issue direction and take such measures as EMSA considers necessary to prevent or reduce the extent of likely pollution by the oil or noxious substance of any Australian waters. Under the Intervention Act, in complying with an EMSA direction, a person has the right to recover their expenses from the owner of a ship for the complying with a direction to provide salvage services. Was it necessarily for the salvor to provide salvage to the third commander? A salvage operation includes any act or activity undertaken to assist a ship in danger at sea. The danger does not have to be actual or immediate or imminent on an absolute. During the trial, an expert witness was called to prepare projections of how far the ship could have drifted between when it broke down to when the Smith Leopard arrived. Owners argued that based on the expert witness projection, the ship was not in imminent danger and that the salvor should not have intervened. However, the court did not agree, holding instead that there was always a real and sensible risk that some unforeseen problem might arise to place the ship and her valuable cargo in actual peril of grounding on the Great Barrier Reef. So thank you for watching and don't forget to like, comment and subscribe.